Happy Monday, and welcome to another episode of Cases that should have gone to the Supreme Court of Canada, but didn't. Today we're talking about driving prohibitions. Cases that should have gone to the Supreme Court of Canada, but didn't. Gurkirat Rai pleaded guilty to a offense of driving while disqualified on the basis of the fact that he understood that although he would be given a lifetime driving ban by the Ontario government because of the convictions, he would be able to apply for his license after 10 years. Unfortunately, he was misinformed, and he wasn't aware that there were additional driving prohibitions that would be added on top, meaning that he wasn't able to reapply for his license once the expiration of the 10 years occurred. As a result, he sought to appeal his guilty plea, arguing that it had not been fully informed. And the court determined that he was fully informed of the consequences and did not allow him to withdraw his guilty plea. And this case raises very important issues about the extent of advice that counsel have to give to individuals about the collateral consequences of their guilty pleas, particularly where there are provincial statutes that impose various consequences in particularly nuanced and unique circumstances. The court here recognized that there is a limitation on the extent of information that counsel needs to inform an individual of, and that there is some burden on the individual to check the veracity of that information or to make sure that it's accurate. But this almost upsets the fairness, particularly when relying on information from counsel and making a guilty plea on the basis of that information. The Supreme Court of Canada had the opportunity here to weigh in on a very important issue. Because lots of offenses carry collateral consequences, and because collateral consequences can be difficult even for lawyers who are legally trained to discern, and especially where they involve the application of numerous different sections of numerous different statutes, this can make it more difficult for people to try and understand and fully understand what they're doing when they're pleading guilty. The Supreme Court of Canada had an opportunity to make things a little more fair when somebody doesn't understand the interplay of all of these different avenues that can lead to them suffering significant consequences as a result of a guilty plea. And unfortunately, the Supreme Court of Canada missed the opportunity to make things more fair for people who are not properly informed of the consequences of their pleas at the time that they make them. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases that should have gone to the Supreme Court of Canada but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.